Welcome to this explainer on the Bhutan Tenancy Act of 2015. Look, whether you're leasing a commercial storefront, renting your very first apartment, or managing a whole portfolio of residential properties, this specific piece of legislation acts as the ultimate referee for the housing and land rental market in Bhutan. We're going to break down exactly what this means for you, completely demystifying the rules of the game.
All right, let's dive right into this officially sanctioned legal framework to understand the exact rules both property owners and tenants absolutely must follow. Enacted by the Parliament of Bhutan back on May 14, 2015, this act wasn't just pulled out of thin air. It was created to maintain domestic tranquility, ensure economic growth, and vastly improve the quality of life by setting clear, undeniable boundaries in the rental market.
To make this complex 34-page law easy to digest, we're going to explore it chronologically. We'll hit the 2015 Tenancy Act basics, creating the agreement, rules for rent, rights and duties, moving out, and finally, resolving disputes.
Part 1. The 2015 Tenancy Act, establishing the referee.
So, who's actually in charge here? Well, the Act relies heavily on the Ministry of Works and Human Settlement to oversee everything at a high level. But your true, on-the-ground authorities, those are your local Dzongkhags, Dzongkhag Thramdes, and Gawags. They are the ones actively managing everything from commercial land leases to private residential homes. Oh, and a quick heads up right away. This applies to almost all government and private leases, but there is one major exception. It deliberately excludes short-term holiday rentals that last for less than 1 month. So yeah, your quick weekend getaways, they don't fall under this heavy legal framework.
Moving on to Part 2, creating the agreement, or what we can call the pregame.
Listen, simple handshakes simply do not cut it under Bhutanese law. Sections 9 through 11 lay out an exact 4-step procedure you must follow to make your rental agreement legally binding. First, get it in writing. Second, sign it, both parties plus 2 independent witnesses, and you've got to slap a legal stamp on it. Third, you must execute this agreement in 3 original copies. Why 3? Because the owner gets 1, the tenant gets 1, and this is absolutely crucial for step 4. The owner is legally mandated to submit that 3rd copy to the concerned local Dzongkhag or Jiwog office within 2 weeks of moving in. It literally creates a clear, undeniable paper trail with the government.
Next up is Part 3, rules for rent. Let's establish some boundaries.
First up, the security deposit. And the Act puts a hard ceiling on this one. The security deposit requested by the owner cannot legally exceed the equivalent of 2 months' rent, period. This is huge because it protects tenants from exorbitant upfront costs, while still giving landlords, a reasonable safety net for damages that go beyond normal wear and tear. Now, the law also tightly controls rent increases. According to Sections 25 and 26, owners absolutely cannot increase the rent for the first 2 years after a tenant moves in. Your rent is totally locked. And when that 2-year period is finally up and the owner decides to revise the rent, the bump cannot exceed 10% of the monthly rent. It's a real game changer that prevents those sudden, massive price hikes that could unfairly force you out of your home or business. But hey, it goes both ways, right? The law isn't just strict on landlords. If a tenant fails to pay rent by the 5th day of the following month, they get hit with a massive 24% annual interest penalty on the amount due. The Act makes it crystal clear. Failing to hold up your end of the financial bargain comes with some steep, calculated consequences.
All right, Part 4, rights and duties. Playing fair.
The absolute crucial point here is balance. The law requires a symbiotic relationship. On one side, the landlord must provide a safe, livable environment, meaning they actually have to obtain a livable certificate from the appropriate authority. On the flip side, the tenant is legally bound to maintain cleanliness, hygiene, and dispose of garbage in the proper place. You can't just trash the place because you don't own it. Let's dig a little deeper into the landlord's boundaries, though. The Act heavily protects tenant privacy. It explicitly states landlords can't just barge into the rental unit whenever they please. No way. They need the tenant's consent, unless there is a genuine emergency. Furthermore, landlords can't arbitrarily shut off utilities or withhold services to punish a tenant. And they're legally required to prevent nuisances, making sure tenants aren't subjected to harassment or annoyance from others. Conversely, let's look at the tenant boundaries. Tenants are expected to use the premises with due care. So you are strictly forbidden from, say, knocking down walls or altering the structure without explicit consent from the owner. You also absolutely cannot use the property for any unlawful purposes. And perhaps most importantly, when it's time to leave, you got to hand over the unit exactly as it was documented in the mutually signed entry condition report, accounting for normal wear and tear, of course.
So what happens when the time finally comes to part ways? Whether you're upgrading to a bigger space or you're a landlord wanting to move back into your own property, how do you cleanly blow the whistle and end the game without breaking the law?
That brings us to part 5, moving out and notices, the end game.
Communication is heavily regulated here. Whether it's the tenant wanting to vacate or the owner wanting the property back for their own occupation, a 2-month written notice in advance is completely mandatory. Now keep in mind, this is actually different from the notice required for a rent increment, which requires a full 3-month written notice from the owner. Basically, the law ensures everyone has ample time to make life adjustments.
But what if a tenant just disappears? Well, the Act actually has a specific provision for abandonment. If a tenant simply vanishes and abandons the property for a period of 2 months, the law considers the tenancy agreement automatically terminated. After notifying the local authority, the owner can legally reclaim the space, pack up any left-behind goods, and safely store them for 2 months before disposing of them. You simply can't leave your landlord hanging in limbo.
And finally, part 6, resolving disputes, when the referee steps in. When things go wrong, the Act prescribes a very specific 3-tiered official dispute ladder. You can't just run straight to the highest court. First, you've got to try to talk it out. If that fails, a party can submit a formal petition to their local dispute settlement committee. Remember those drunkags and gaywogs we mentioned earlier? They'll hear the matter and issue a written decision. If you're still unsatisfied with that local decision, you have exactly 10 working days to appeal directly to the Royal Court of Justice, who acts as the ultimate decider.
But I really want to highlight Section 91 because it's beautifully simple. It explicitly states, the parties shall amicably resolve any dispute arising from the tenancy. Basically, before launching into stressful legal battles, local committees, and court appeals, the very spirit of the law asks landlords and tenants to just sit down and strive to settle their differences like reasonable partners.
As we wrap up this explainer on the Bhutan Tenancy Act of 2015, take a moment to reflect on the strict boundaries we've explored today, from that ironclad 4-step agreement process to the 2-month deposit caps and those strict eviction timelines. The law really leaves no room for ambiguity. So ask yourself, if a dispute started tomorrow, would your current lease agreement be your ultimate shield or your biggest liability? Take this knowledge, protect yourself, and thanks so much for exploring this with us today.